There are some important considerations in antitrust law that are probably better addressed in a lecture than in the textbook. But these considerations are technical and worse yet, they involve math. So I thought the best option would be to provide you with a recorded lecture on the topic. This way you can stop to consider the material whenever you want, and you can rewind and revisit the portions that you feel need to be repeated. There are a number of antitrust laws, but there are two statutes with three separate provisions that we care about the most. The first is Section 1 of the Sherman Antitrust Act. It provides every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce amongst the several states or with foreign nations is illegal. If you took that literally, then it would mean that a lot of contracts are illegal. For example, let's talk about LeBron James. In 2016, LeBron made about $54 million by endorsing products. Compare that to the just over $23 million that he made playing basketball. One of LeBron's big endorsement contracts was with Nike. I have never read his contract with Nike, but I am absolutely certain that it prohibits LeBron from endorsing any of Nike's competitors' products. That means LeBron is restrained from entering into a contract with Adidas. And it means that Adidas is restrained in that it can't have LeBron endorse its products, no matter how much it's willing to pay. So the contract between LeBron and Nike clearly does restrain trade, but it's not illegal. It doesn't violate the Sherman Antitrust Act. Even though the language of Section 1 of the Sherman Antitrust Act is broad, it has been interpreted not to prohibit contracts that restrain trade, but to prohibit contracts that unreasonably restrain trade. The second provision that we need to focus on is Section 2 of the Sherman Antitrust Act, which prohibits monopolization by unlawful means. The final provision is the Clayton Act. There are several provisions in the Clayton Act, but the one worth mentioning here is the provision that prohibits mergers between two businesses if the merger has an anti-competitive effect. The focus on an anti-competitive effect is relevant in all three provisions. The purpose of these three provisions is to encourage competition because most economists, and certainly most capitalists, agree that the more competition there is amongst someone providing goods or services, then the lower the cost will be to those of us who are paying for those goods or services. Since the antitrust laws are to be applied to prevent anti-competitive effects, there has to be some way to measure the anti-competitive effect of a contract that restrains trade, the anti-competitive effect of someone who's acquired a monopoly, or the anti-competitive effect of a merger. As a first step, courts often look to the market power that a company has. But instead of measuring anti-competitive effects, we're measuring market power, so we need a way to do that. But even before we try to do that, we need to figure out what market power is. Economists might define market power as the ability of a business to raise or maintain prices above the level that would prevail if there was unfettered competition. Some economists use the phrases market power and monopoly power interchangeably. Having market power is not a bad thing for a business, but it is bad for consumers. If a business can raise its prices and we don't go somewhere else, it's likely that's because there is nowhere else to go to. In a perfectly competitive market, market participants, the businesses selling the particular good or service, have no market power. A major goal of the antitrust laws, therefore, is to limit the opportunities to gain market power. In a monopoly, prices are high. If there's only one store I can go to, that store can charge me pretty much whatever they want to charge for the things that I need. If there's two stores to go to, the prices are going to get lower. And if there's a handful of stores, they're going to get lower still. And if there's a lot of stores, the prices will be competitive, or they'll be at what an economist will say is the lowest point that natural market forces will allow. That means that in an antitrust case, one of the questions that is commonly asked is whether someone has or might acquire too much market power. But before we get to the question of how much market power is too much market power, we need to answer yet another question. We have to answer the question, what is the market? It seems like a simple question, but it turns out that it's kind of complicated. Market can mean at least two things. The market can be a geographic market, or it can be the market for a particular product. We're going to start by talking about geographic markets, and then we'll talk about product markets. Geographic markets concern themselves with the physical area from which you're going to draw your customers. Suppose that in the entire country, there's only two sporting good chains. There's Joe's and there's David Bowen's, each with stores in cities across the country. Prices at these stores are, at least to some extent, kept in check, because if Joe's has been selling Nike golf balls for $8 a sleeve, and David Bowen's is selling a sleeve of Nike golf balls for $12, market forces is going to send us to Joe's when we want to buy Nike golf balls. And since David Bowen will want at least some of that business, it's going to drop its prices. But what happens if Joe's and David Bowen merge into a single business, a single entity? The resulting new store, now maybe called Joe Bowen's, can raise its prices because we really don't have anywhere else to go. Letting the two companies merge could have a decidedly anti-competitive effect, as they might have the power to raise prices not only on golf balls, but on golf clubs as well, and that would be seriously bad. But instead of saying there's only two chains in the entire country, what if there's only two chains in New Mexico? Will there still be the same anti-competitive effect? For those of us who live in towns near the state line, it won't have as big effect on those who live in the center of the state. I might drive to El Paso to look for a good deal. After all, it's only a 45-minute drive. But I have friends in Albuquerque. If they only have one choice in New Mexico or two choices in New Mexico, are they going to drive several hours to Phoenix to save money? So having a monopoly in New Mexico will still have an anti-competitive effect, but not as big an effect as a national monopoly would. What if Joe's and David Bowen's are the only two sporting good chains in Las Cruces? As I noted, I'd be willing to drive 45 minutes to El Paso to save $100 on a set of clubs. But how many of us are willing to drive 45 minutes to save $5 on some golf balls? So there will be some anti-competitive effect, but not nearly as much as there would be if they were the only choices in the entire state. What if David Bowen's and Joe's were the only two on the east side of Las Cruces? Oh, it's going to have much less of an effect, as it's pretty easy to drive from one side of Las Cruces to the other. Obviously, the larger the geographic area that someone has market power in, the larger the anti-competitive effect. Deciding what is the relevant geographic market depends on the product, the price point, the nearest competition, and the ability to buy over the internet. There is no precise one-size-fits-all formula to measure market power. Each case has to be decided on its own unique facts. Let's look at the idea of the geographical market in the context of a sports case. I want you to meet Rhiannon Tanaka. Rhiannon was a star high school player and was heavily recruited by a number of universities, including the University of Southern California, which belongs to the Pac-10 conference. Rhiannon later filed a lawsuit in which she claimed that when she was being hustled by USC, when they were asking her to attend their school, she specifically asked about transfer restrictions. And USC specifically told her that there were none. Provided that she remained at USC for 1 year and met minimum academic requirements, which she certainly did, they told her that she would be free to transfer from USC to any other school. After those conversations, she signed a letter of intent with, and later went to school at, USC. After a year at USC, Rhiannon was very dissatisfied with both the soccer program and the academic program. She publicly claimed that USC made arrangements for athletes to get credit for classes they didn't take. She claimed that her academic reputation would suffer as a result. She began to communicate with other schools about transferring, especially to a soccer school, but because she wanted to stay in Los Angeles, where her family was, and because the University of California's soccer program was nationally ranked, she decided to transfer to UCLA, which is also part of the Pac-10. After her transfer, USC petitioned the Pac-10 to keep Rhiannon from playing for UCLA, and they pointed to a Pac-10 rule that provides that if a student transfers from one Pac-10 school to another Pac-10 school, the student is ineligible to play for 2 years, but even then they're charged with 2 years of eligibility. This rule had never been relied upon before. But as a result of USC's challenge, Pac-10 agreed and told her that she could not play for the next 2 years, but would lose 2 years of eligibility. Rhiannon sued, alleging a Sherman Act violation. She claimed that the agreement amongst all of the member schools of the Pac-10 restrained trade and that it kept her from buying the academic services that she wanted to buy. The Pac-10 is much like the NCAA in some regards. It is supposed to be there to make sure that college sports are amateur sports. To the extent that its rules concern themselves with either academia or student safety, the rules are non-commercial and aren't subject to the antitrust laws. But Pac-10 rules that involve sports as a business are subject to the antitrust laws and are governed by the rule of reason. The trial court held this rule was non-commercial and therefore wasn't subject to the antitrust laws. It went on to say that even if it was wrong and the rule was commercial, then it was reasonable rule under the rule of reason. Rhiannon lost her case and she filed an appeal. Under Section 1 of the Sherman Act, an agreement is illegal if it unreasonably restrains interstate commerce. And under the rule of reason, it unreasonably restrains trade if its anti-competitive effects outweigh its pro-competitive effects. To start the analysis, the plaintiff has to prove the restraint has significant anti-competitive effects within a relevant market. And that meant the court had to figure out what was the relevant market for college soccer players. The court said that the geographic market is the area of effective competition where buyers can turn for alternative sources of supply. Rhiannon, as the plaintiff, had the burden of alleging what the relevant market was and then proving that allegation to be true. She claimed that the relevant market was Los Angeles. If she was right, then she was going to win the case because Pac-10 has huge market power in Los Angeles. There just aren't very many options for soccer players in Los Angeles except at Pac-10 schools. The Court of Appeals held that while Rhiannon might want to stay in Los Angeles, she had failed to prove that was her only realistic option. The court pointed out that she alleged that she had been heavily recruited by colleges from across the country. The Pac-10 rule was an intra-conference rule and would not impact her ability to play outside of the Pac-10. Since she could play anywhere in the country other than within the Pac-10, she had lots of options, so there was very little anti-competitive effect. Rhiannon lost her appeal, not because the rule was good or right or fair or just, but because it didn't have an anti-competitive effect on the relevant geographic market. So the geographic market is the area where people can be expected to go to shop for a competitor's particular product. And in a world with increasing international sales due to the internet, what constitutes the geographical market is certainly and rapidly changing. The Court of Appeals in Rhiannon's case gave us a perfect segue to talk about product market, as it clearly said that unreasonable market power exists if the business had unreasonable market power in a geographic market or in a product market. And then the court defined the product market using some very strange language. The product market includes the pool of goods and services that enjoy reasonable interchangeability of use and cross-elasticity of demand. It would be great to say that the court's opinion tells us what market power is with regard to products, but it helps us understand market power only to the extent that we understand the magic phrases it used, reasonable interchangeability and cross-elasticity of demand. Cross-elasticity of demand is not a legal term, but a term in the field of economics. None of us will likely become experts in that field, but we need to know the concepts and we need to appreciate the jargon. Let's step out of sports for just a minute and consider the concept of price elasticity in a more conventional setting. Evian sells glass bottles of mineral water. I have no clue what its market share is. Let's pretend it has 34% of the US market for all glass bottles of mineral water. Perrier also sells glass bottles of mineral water, and we're going to pretend that it has 44% of the US market. If Perrier and Evian merge, will it have an anti-competitive effect on the market? Sure it will. It not only has a combined 78% of the product market nationally, it has loyal customers, it has shelf space, it has a recognized brand. Stores and consumers will both want to continue with either Evian or Perrier, due in part to the fact there are few recognized alternatives. If, before the merger, Evian raised its price, I can switch to Perrier, or if Perrier raised its price, I can switch to Evian. But if they merge and they raise the price for both, consumers will simply have to pay more. Or will they? If you drink Evian or Perrier and the price went up 5%, what would you do? They have 78% of the market, and they're going to be in all of the big stores. They're going to be the easiest to find. You might find another brand of mineral water in a glass bottle, or you might find mineral water in a plastic bottle, or you might switch to spring water, or you might even switch to Coke. So you have more options than finding a competitor for a company that sells glass bottles of mineral water. You can switch to a different type of bottle, or you can switch to a different type of drink. The question now becomes whether it's reasonable to assume that these other products, plastic bottles of mineral water or other types of drink, are realistic alternatives to glass bottled mineral water. Whether the merger between Evian and Perrier is anti-competitive, whether it would give this new company too much market power, depends not only on the options that people have, but on whether they will actually take those options. It depends on what in the trade we call the reasonable interchangeability of the products. Reasonable interchangeability involves having reasonable substitutes. If the price goes up a whole lot and everyone buys the same product, they obviously don't have reasonable substitute. And we're going to find there are no reasonably interchangeable products. But if a significant number of people change products at 5% increase in price, then we know that there are substitute products, and the product market must include those which can be substituted. SNP is a fancy acronym that simply means small but significant non-transitory increase in price. The phrase SNP refers to a test used by economists in courts when they consider the effect of a price increase. The SNP test imagines that there is but a single business dealing in a claim to market. No one else does or will sell the same product. It's a fiction. It assumes that the seller will want to increase its profits by maximizing the price and will therefore raise the price as much as it can. The SNP test seeks to see what happens as the prices are raised. In essence, it looks to see whether customers think there are other products that are reasonably interchangeable. The application of the SNP test involves interviewing consumers regarding buying decisions and determining whether a hypothetical monopolist or cartel could profit from a price increase of 5% for at least a year, assuming that the terms of sale of all other products are held constant. If sufficient numbers of buyers are likely to switch to alternative products and the lost sales would make the price increase unprofitable, then the hypothetical market should not be considered a relevant market for the basis of litigation or regulation. Imagine I have a market in toilet aquariums. If I raise the price 5%, will people keep buying it? I suspect that I may be the only person in the country selling toilet aquariums. So if someone really wants or needs one, they're going to have to pay that new price. But I suspect that toilet aquariums aren't really needed by anybody and are wanted by few. And those few might lose interest and find something new, like a stove aquarium. The SNP test is often measured in terms of something called the price elasticity of demand. The price elasticity of demand is a measure used in economics to show the responsiveness or elasticity of the quantity demanded of a good or service to a change in price. Let's talk golf clubs. A company's highest profit would come from selling lots of a product at a very high cost. But the simple fact of the matter is that the lower the price, the more it will sell, and of course the opposite is true. The higher price, the fewer clubs it will sell. That means if you raise the price, you'll decrease the number of clubs you'll sell. But how do you quantify it? It turns out there's a specific formula for it. And now we get into the math. The formula is the change by percent in demand divided by the change in percent in price equals the price elasticity. Since it would be a strange thing to sell more product if you increase your prices, the resulting number is almost always a negative number, except for something called Veblen goods and Gifford goods. Veblen and Gifford were economists who theorized that price just doesn't matter to some people for some goods. If you can afford a Rolls-Royce, and if you want a Rolls-Royce, it probably doesn't matter if the price goes up. You're still going to buy a Rolls-Royce. In fact, Veblen and Gifford went farther and theorized that for some stuff, the more it cost, the more likely it would be that someone would buy it, since the price itself was a status symbol. But Veblen goods and Gifford goods are few and far between, and are nothing we'll ever deal in this class. We won't work in Veblen or Gifford goods. But I'll tell you this, there may be an opportunity for extra credit if you can tell me about Veblen and Gifford goods later on. The number of golf clubs that you'll sell is proportional to the price of the clubs. The cheaper the clubs, the more that gets sold, and conversely, the more expensive the club, the fewer you'll sell. Let's do the math and figure out how we quantify it. If by increasing the price by 20%, the number of sets sold decreases by 10%, the price elasticity is negative 0.5. If by increasing the price 10%, the number of sets sold decreases by 20%, the price elasticity is negative 2. Generally, courts look at a price elasticity of -1 as a magic number. If the price elasticity is -1 or higher, and remember, we're talking about negative numbers, then the seller has market power. I'd encourage you to hit pause and determine the price elasticity in each of the following examples I'm going to provide. If you have any problems with any of them, come see me. You will need to understand how to do this for the exam on this chapter and for the final exam. In the examples we worked through together, we were talking about the effect that the price of golf clubs would have on how many people buy golf clubs. But it turns out the price of golf clubs may affect other things than the sale of golf clubs. Can it affect the number of people that will play golf? It seems to me that if the price of golf clubs goes up or down, it will have an effect on the number of people who will pay green fees. Spend just a few seconds and anticipate the line that will show the effect here. What do you expect to happen? Sure, it's going to go down. The more golf clubs cost, the fewer people will own them. The fewer people with golf clubs, the fewer people will play golf. In economics, the cross elasticity of demand or cross price elasticity of demand measures the responsiveness of the demand for one good to a change in price of another good. To measure the cross price elasticity of demand, we use the exact same formula as before. It's measured as the change in percentage of demand for the first good that occurs in response to a percentage change in price of the second good. For example, if in response to an increase of price of 10% in the price of golf clubs, the demand by golfers willing to pay green fees decreased by 20%, the cross price elasticity of demand will be a -2. A negative cross elasticity denotes two products that are complements, which means that if you want or have one product, you're likely going to want the other one. And conversely, if you don't have one, you're probably not going to want or need the other. If I have golf clubs, I probably want golf balls. And if I don't have golf clubs, I'm less likely to want to buy golf balls than someone who actually golfs. Let's look at the effect of the price of golf clubs on the sale of golf balls. We know that as golf clubs get more expensive, people are less likely to have them. And if people don't have clubs, they're less likely to play golf. And if they're less likely to play golf, they're less likely to buy golf balls. Though they may still need to buy some golf balls if they aren't golfing, to use for putting practice or to play jacks with. The fact of the matter is, it's not enough to know that in concept this might be happening. We need to be able to do the math to quantify this relationship. If the price of clubs increases by 10% and the demand for golf balls decreases by 5%, the cross-price elasticity of demand is a negative 0.5. Would increasing the price of golf clubs affect the sale of golf hats? If I'm not on the course, I may not be as interested in buying a golf hat, but somebody else may want to buy a golf hat as a matter of style, but not to play golf. If the price of golf clubs goes up by 10% and the number of hats being sold goes down by 2%, then the cross-price elasticity of demand is a negative 0.2. Up to this point, we've been talking about a negative number for cross-price elasticity when products are complementary. But if you can substitute one product for another, if the products are interchangeable, then the cross-price elasticity will be a positive number. If the price of golf clubs goes up, then people may turn to another sport, say croquet. If that happens, then the more expensive golf clubs become, then the more sales there will be of croquet sets. If the price of clubs goes up 10% and the demand for croquet sets goes up 8%, then the cross-price elasticity is going to be 8 divided by 10, or 0.8, a positive number. A positive number reflects competitive products, which means that if you can't afford one, you will buy the other as a substitute. Will an increase in the price of clubs affect the sale of SUVs? While I might use my SUV to haul my clubs in, even if I don't have clubs, I'm still going to buy an SUV because I use it for a lot of reasons besides hauling my clubs. So if the price of clubs goes up 10% and the demand for SUVs remains unchanged, then the cross-price elasticity of demand is 0. There's no correlation between the two. I'm going to leave you with a couple of questions that I want you to sort through. If the price of roller skates goes up 10% and the demand for inline skates goes up 22%, first, determine what is the cross-price elasticity. Second, determine whether the products are complementary or whether they're competitive. Okay, quick summary. The purpose of the antitrust laws is to protect competition. Competition is good. Things that are anti-competitive aren't necessarily illegal. They're going to be illegal only if they're unfairly or prejudicially anti-competitive. In deciding whether something is unfairly anti-competitive, we look to the market power that the person charged with the antitrust violation has, both geographic and market power with regard to the product. And we do that by determining the price elasticity of demand or the cross-price elasticity of demand to look for substitute products. As always, should you have any questions or concerns about this or anything else, I invite you to stop by my office and talk it through. I'll see you back in class.